All right, Blair, we are all set.
All right, good afternoon all and welcome to this webinar titled Beneath the Surface, Rethinking Mining Law for a Just and Sustainable Future in East Africa. This webinar is organized by the East Africa Law Society Mining Law Cluster, and it is my singular and distinguished honor to moderate it. My name is Blair Michael Ntambi. I'm a lawyer by profession and a member of a Ugandan bar. I'm also a mineral development advisor at GIZ Uganda. I'm joined by a powerhouse of five distinguished legal minds and policy leaders from across the East African Law Society member bars. And I would like to briefly introduce them to us all before we get started with our conversation. Our first speaker and panelist tonight will be Ange Doreen Irakoze, who is a partner and chief operating officer at Robert and Company Advocates. Ange, we happy to have you this afternoon. Shall also be having Lynn Gitu, who is a lawyer as well, program lead at Impact, based in Uganda. We shall also be having our third panelist as Pooja Mahindra Karya, and I hope I'm pronouncing that correct. She's a founder consultant at E&E International Consultants in Tanzania. She'll also be having Cynthia Opakas, who is a fellow at the Institute of Arbitration, and she's legal counsel for Greenmarks Capital Group based in Kenya. Last but not least, she'll be having Daudi Ramadani, who is a partner at Rex Attorneys in Tanzania. Ladies and gentlemen, this is a very timely webinar that will be exploring issues that pertain to the mining sectors in our countries in East Africa. But to set the scene, the East African Law Society intended to bring it to the audience, which is already known, that East Africa is a home to extraordinary mineral wealth. We have so many minerals: gold, cobalt, gemstones, rare earths, to mention but a few. And this creates an opportunity for us all to drive sustainable development. And for us lawyers to drive sustainable development, especially on the side of fronting policy. Policies that are inclusive, policies that prioritize people, policies that prioritize communities and the environment. But the reality on ground is that land dispossession is prevalent, environmental degradation is prevalent, and many people, especially the mining communities, are left behind, where we believe these resources should be a blessing. In some instances, they are synonymous to a curse. So this webinar is set to reimagine mineral law in East Africa as a tool to foster social justice, equity, sustainability, and to bring together legal minds across our different bars to see how we can forge a way forward, to see that mineral wealth can uplift our societies, and mineral wealth can provide sustainable jobs for our lawyers and all key stakeholders with a legal background in this very lucrative sector. That said, I want us to get straight into the webinar. We have various conversations, and one of them is going to be, and you'll forgive us for insisting on starting this way. We shall be having our first conversation on mining, gender, and equity, and having a conversation on legal reforms for inclusive resource justice in East Africa. The presenter for that will be none other than Ange.
Thank you, Blair.
Irakoze. Ange, over to you to set the scene.
Thank you so much, Blair. Allow me to first share my screen. Hope you can see it.
Yes, we can.
Okay. That's great. Hello, everyone. Good afternoon, distinguished colleagues across East Africa. I'm deeply honored to address the East African Law Society today on gender equity in mining and extractive industries, an issue at the intersection of law, economics, and human rights. As we gather virtually across our wonderful region, from Kenyans Great Rift Valley to Rwandan's Thousand Hills, from Tanzania's Kilimanjaro slopes to Uganda's fertile highlands, from Burundi's tea plantations to the vast landscape of DRC, from South Sudan's oil fields to Somalia's emerging coastline, we share more than geography. We are united by the regional's mineral wealth, yet we face a common challenge ensuring that East African abundant mineral wealth benefits all our people, regardless of gender. As Blair has mentioned, our region abounds in extraordinary resources, gold in our rivers, tin in our mountains, precious stones beneath our soil. Yet, while mining generates billions in revenue, half of our population remains excluded from its benefit. This is not just economic inefficiency, it is profound injustice that our legal system can correct. So today, I will show how comprehensive legal reforms can enable the mining industry to move from continuing inequality to promoting inclusive resource justice, a transformation both possible and essential for sustainable development. Allow me to start with few stories that reflect the topic I'm trying to address today. In one of our ESC countries, a gold mining cooperative, Fatu, a lady, has spent 12 years mastering mineral processing and training other miners. Her innovations increased productivity by 30%. However, when the cooperative seeks formal registration, traditional norms dictate that only men can hold official positions. Despite being the most knowledgeable member, Fatu is relegated to an assistant role on paper. She cannot sign contract, access credit, or represent the cooperative in negotiations. Her expertise remain invisible to buyers and policymakers who only meet with male representatives. This exemplifies normative gender injustice. Another story is about Grace, who leads a women's mining cooperative that has successfully operated a tin mine for 3 years. When they applied to expand their operations, the mining board, comprised entirely of men, reject their application without proper review, citing concerns about women's technical capacity. Meanwhile, a less experienced male-led group receives approval within weeks. This is institutional gender injustice. In another country, Fatima discovers environmental violations at a large mining operation affecting her community's water supply. When she attempts to file a complaint with the mining authority, she's told the forms must be completed in English, a language she does not speak, and requires male family member authorization. The nearest legal aid office is at 2,000 kilometers away, and the filing fee costs 2 months of her income. This is procedural gender injustice. So these stories reflect systematic regional exclusion. Women control less than 5% of mining licenses despite significant involvement. They also constitute less than 10% of former mining workers and face 30 to 40 percentage wage gaps. Yet women represent over 60% of East African population while remaining marginalized in decisions affecting their communities. This exclusion manifested in four interconnected areas, as you can see on this screen. First, legal and structure exclusion through customary prohibiting women from owning claims, reinforced by patrilineal inheritance systems, passing mineral-rich lands exclusively through male lineages. Our mining policies compound this through gender blindness, systematic failure to recognize how gender influences every mining aspect. Second, profound economic marginalization relegate women to informal, lower level value activities while men dominate high value operations. Financial exclusion creates an additional barrier. Traditional banking models don't accommodate mining specific needs, particularly in artisanal sectors where many women work. And also social and cultural barriers construct mining as a male domain. And finally, women bear the heaviest environmental burden while being excluded from environmental decision making. Recognizing these challenges, let me turn to examine how the international community, our regional bodies, and also national government have begun to respond. The landscape of legal responses reveals both promising progress and significant gaps that demand our attention. International frameworks have emerged addressing gender inequalities. The UN Global Compact's Women Empowerment Principles provide business conduct frameworks, while the Extractive Industries Transparency Initiative promotes inclusive governance. The OECD due diligence guidance requires human rights impact assessment, including gender-based violence. However, effectiveness depends entirely on national implementation. African regional initiatives show greater recognition. The AU Mining Vision calls for women's empowerment in mining value chains, while the Maputo Protocol guarantees economic participation rights. The International Conference on the Great Lake Regions addresses conflict minerals with women and children protections. Within the EAC, we've seen significant development. The 2018 Gender Policy seeks inclusive community, guaranteeing equal opportunities, built on our EAC treaty, which commits to gender equality principles. The East African Legislative Assembly passed the Gender Equality and Equity Bill in 2017. Also, strategic frameworks include the Gender and Community Development Strategic Plan, which provide mainstreaming guidelines, yet significant implementation gaps persist. Enforcement measures remain weak, with limited coordination and insufficient funding. Policy coherence issues emerge where customary and statutory law conflict, while inconsistent application undermines regional effectiveness. These gaps reveal a crucial recognition. Incremental reforms are insufficient. We need comprehensive legal transformation addressing the root causes. This brings me to my presentation's heart: comprehensive legal reform, transforming mining into inclusive resource justice. I'm advocating for a whole of society approach rather than piecemeal interventions. Legal transformation begins at the constitutional level. Our constitution have to enshrine gender equality principles directly into mining frameworks, creating constitutional mandate for gender responsive governance while integrating our customary values. Building on this foundation requires comprehensive mining code reform. Every code must include mandatory gender provisions, establishing at least 30 to 40% women's quota in boards and regulatory bodies. We need also gender-specific licensing with reserved allocation and mandatory gender impact assessment. Another layer will be property and land rights reform that represent a crucial pillar in this approach. We must establish women's co-ownership rights in customary land with mineral potential and create inheritance mechanisms for women's independent rights. Institutional reforms must accompany proper changes. We need specialized mining courts with gender expertise, fast-track procedures for gender disputes, and regional court systems for cross-border justice. Regulatory agencies require gender unit with expertise requirement and women's representation quotas backed by law. Economic justice demands specific reforms, legally prohibiting gender-based financial discrimination while reforming collateral laws, recognizing women's diverse ownership. At the ESC level, I'm of the view that this is the very significant pillar. We need harmonization of gender-responsive laws across ESC states, regional mining courts with gender jurisdiction, and mutual recognition of women's mining rights across borders. Returning to my stories, imagine transformation through our discussed reforms. This transformation represents more than individual access. It's economic justice our region deserves. Gender inequality in mining affects our entire development potential. 3 critical points guide us forward. Legal transformation must be comprehensive, addressing substantive justice beyond formal equality. Regional cooperation is essential. Harmonized laws and enforcement create consistency and scale. Cultural sensitivity really matters. Reforms must respect East African values while advancing equality. As East African society members, we must champion progressive interpretation, advancing gender equality, advocate for legislative reforms, build legal capacity for gender responsive practice, and support women's access to justice. I challenge you to live committed to action after this webinar. In law firms, take cases advancing gender equality. In courtrooms, interpret laws protecting women's rights. In policy work, advocate for comprehensive reforms. In communities, educate about legal pathways to equality. East African's mining transformation from inequality to inclusive development champion is within reach. Thank you for your attention and commitment to equality and dedication to building a more inclusive East Africa. I look forward to our discussion and working together to make this vision reality. Thank you again for your attention.
Thank you very much. That was Ange Dorini Rakoze, who's a partner and chief operating officer at Rubea Company Advocates in Rwanda. And I believe Ange has set us off well with a good conversation on some of the key issues that affect us as East Africans, especially aspects of access to justice for women, who are a key stakeholder population in the mining sector. I'm going to invite Lynn Gitu to come on board, and I would kindly request that Lynn, you get to introduce yourself so the listeners can get to know you better. I know you have great expertise on aspects of governance, and I know your conversation really ties in well with what Ange was presenting. So I would like to hand over to you to navigate the questions of power, land, and justice trilaterally to see how best we can invoke conversation around policy on these aspects. Over to you, Lynn.
Thank you, Michael, and hello to everybody. Good morning, good afternoon, good evening, depending on where you are. My name is Lynn Gitu, and I lead the work of a Canadian international NGO called Impact. Impact has been operating in Africa's Great Lakes region and across the world for 30 years. Our main focus is natural resource management, and to be very specific, we are passionate about the artisanal and small-scale mining sector and women's participation in that sector. The work in Uganda has been happening for the last at least 10 or so years. Since 2015, we've worked together with the government of Uganda, the Ministry of Energy and Mineral Development, Ministry of Finance, Ministry of Trade, Industry and Cooperatives, Ministry of Gender, Labor and Social Development, across the board as regards ministries, departments and agencies, as well as local communities, local governments, miners, with again a particular passion for female miners, and so I really loved your presentation, Ange. You hit all the nails on the head. Okay, so I'll get into the conversation around power, land, and justice, and putting communities at the center of resource governance in our region. So this has already been said. I'll just go over it quickly. The East African region is currently home to 300 million people, even above that. It's a region that is full of, that is rich in minerals, in forests, oil, water. All of these are natural resources that are supposed to support the growth and development of the people of East Africa. However, what has been true is more resource-linked conflict, displacement, and elite capture of the resources that are available within the region. What lies at the heart of these struggles really is a deep imbalance in power, a history of land dispossession, as well as unfulfilled quest for justice. So this afternoon, we will, for a few minutes, ponder how do we transform resource governance into an avenue for peace, for equity, and dignity from the community level going upwards. So just look briefly at resource wealth, conflict, and displacement. Once again, just to repeat, just to say, to get into our minds how rich this region is. Gold in Eastern DRC and across Uganda. Impact is the executing agency of United Nations Environment Program project that is codenamed Planet Gold, and Planet Gold is supporting miners across the country to move away from the use of mercury. Ange hinted on it as she spoke of the Global Mercury Partnership. This is an initiative that has been happening for a number of years now, and the idea is to eradicate or eliminate the use of mercury in the artisanal and small-scale gold mining sector. So across Uganda, believe it or not, there is substantial deposits of gold. There's tin, there's coltan. All of these minerals are important for the electronic sector. There's oil, there's tanzanite in Tanzania, there's precious gemstones in Kenya, there's oil and gold in South Sudan, there are forests in the Congo Basin, there's fertile land in Burundi and Rwanda, to mention but a few. Our region is really rich. This abundance, though, leads to conflict and all kinds of injustice. Artisanal miners, who form 90% at least across the region of the producers of minerals, face criminalization, and while large-scale actors get tax breaks. And the conversation often across the region is that artisanal mining is not provided for in the laws, or if it is provided for, then things are not very clear. Their operation is not very clear. Uganda has moved a number of steps forward in terms of including the artisanal and small-scale mining sector within the law and providing, boundaries for how they can operate and so on. But challenges continue to exist. Communities are displaced without consent or fair compensation across the region. This is not a one-country problem. Land is grabbed through elite networks as soon as there is an understanding amongst the elites about the abundance of a certain mineral or oil in a certain place. Then they go and buy the land at cheap or literally grab it, knowing very well that when the project begins, they will benefit directly. We have issues of opaque concessions or contracts or agreements between mining companies and governments across the region. These contracts and agreements and concessions ideally should be available as public documents because these are public resources. But despite initiatives like EITI and some regulations like the EU conflict minerals regulations and so on that have this provision for transparency and accountability, many countries within the region are not providing these critical agreements that would be important for communities, for people to understand how much they have, how much the government is going to get, and how much is going to come back to solve the myriad issues that they have at the community level. Resource governance in this region is deeply political. It's shaped by colonial histories, militarized economies, and weak enforcement of community rights, among other challenges. So who holds land and who loses it? Who makes the decisions about land and resources? Because it's only when you are able to make a decision about a resource that we can say that you have power. The people who make decisions about land and resources are often not the communities who have lived on that land and depended on it for generations. Customary land tenure systems, which many communities rely on, are poorly recognized in law across the region. This is true. We know this for a fact. Foreign investors and political elites can access land through state concessions, but communities lack documentation. They're always shut out of conversations because, oh, you don't have the proper documentation. Oh, you don't have the right legal representation. Can you afford it? No. And I like how Ange mentioned as she closed her presentation, calling on the legal fraternity across the region. Take up cases, be willing to be courageous and get into this sector and support communities to speak up against power or speak up to power. Women and youth are routinely excluded from land ownership and decision making, even when they bear the largest brunt of displacement. In effect, therefore, land and resource governance often protects the powerful and not the people. Let's talk a little bit about justice, what communities demand but so rarely get. Justice means, to us at least, at Impact and to the different partners that we have worked with for many years, it means more than access to courts. It means recognition, restitution, and participation. Do I have a place to go when I have a grievance? Am I going to be compensated to the extent that preserves my dignity and preserves my identity? Across the East African region, justice for communities ideally would look like this, in our opinion. It would look like being consulted and consenting before projects start through genuine, free, prior, and informed consent processes, not some of these processes that we are all aware of across the region, where the small meetings, barazas, or things like that are held, and things are said, a lot of English, a lot of French, a lot of Swahili, whatever the language. And then people are made to sign documents here and there, or there's just this general agreement. So do you agree that we should come and set up this project? It's good for you. And somehow the yeses from a crowd of people are considered as FPIC. Receiving a fair share of resource revenues to support schools, health, and livelihoods generally. In across the region, in our mining laws, I think one provision that seems to be standard is this sharing of royalties between central government, local governments, landowners, and in some cases, traditional leaders or traditional or kingdoms, clans, and those structures. However, many times, communities through their local leadership, as well as landowners, will share their stories of how those revenues do not reach them. And in any case, it goes back to what I was saying in the beginning. If we don't know how much the company has committed to providing to the government, stroke what the government is going to receive from this company's work in our community, how are we going to ask for our fair share of the revenues? How are we going to ask for our 10%, 30%, 5% of royalties? Across the region, justice for communities would look like having access to independent grievance mechanisms, not just politically influenced courts, because we know across the region, this is the truth on the ground. It would look like seeing environmental protection enforced so that their land and water are safe for future generations. In Uganda, I will speak about the law prohibiting the use of mercury. But how does mercury get into the country? How come it is not stopped at the borders? How does it end up into our water and our land, our food and our fish? Too often, communities are expected to just accept development because it's good for you without being part of it. That's not justice. It's exploitation dressed as progress. As I come to the close of my presentation, let's consider what putting communities at the center could look like, practical pathways to fix what is broken. Legal empowerment. I think Ange has mentioned this. Train communities to know and assert their land and resource rights, especially women, youth, and indigenous groups for the places where these groups exist. Recognition of customary tenure. Align national laws with traditional systems and document land ownership where possible, because land is land. Land is identity for people across this region. Strengthen community consultation laws to make free, prior, and informed consent real and not just rhetorical, as I described earlier. It would look like ensuring benefit sharing mechanisms which are community-led and not company-dominated. We have some success stories in Uganda, in the Karamoja region, where community development trusts have been set up with the support of development partners, and even amongst themselves, they have a very strong community bond, and a couple of times community development trusts have been set up, and these have supported the communities to receive their fair share of revenues. Support community-based monitoring. The communities live in these places. So why can't they be involved in monitoring the work of mining companies, for forestry or loggers, the kind of companies that make turn wood into timber? How about oil activities? When communities monitor, they can hold duty bearers better accountable. And I think crucially, again, I will refer to Ange. Thank you so much, Ange. Your presentation was so brilliant. Support cross-border learning and advocacy in the region, because the problems are shared. The solutions must be shared too. In closing, if we are serious about sustainable development, peace, equity, security, and all these things in our region, We must rethink how we govern land and other natural resources. And the people, a big a part of the people on this call, we are in the places and the spaces where we can begin to push these conversations and make sure that we get where we need to get. We must redistribute power from central capitals and corporate boardrooms to the community level. This is possible. Again, as I mentioned about the Karamoja region, these people have agency, they have voice, they have ideas, they know what they want. They don't need to be, gaslit with our English and French and Swahili and big size ideas. Let's redistribute the power to their level. We must center justice, not just in the law books, but in lived experiences. And this can only happen if the legal fraternity is willing to go down to the community level and move from these high level discussions. We must treat communities not as obstacles, but as rightful owners and stewards. True resource justice is not about extraction. It's about belonging, it's about dignity, and it's also about voice. I want to thank you very much for these few minutes of your time. Asanteni sana.
All right. Thank you very, very much, Lynn. I think you invoke a right spirit in legal professionals, especially to decentralize transparency and access to justice conversations, delocalize most of these conversations for the sake of our communities that actually accommodate these resources. That for me is something that I felt came out so strongly, and I don't even think it's just an East African thing. And that's why I want to invite our next speaker to see how broad this can get, how vast this challenge is. Our next speaker is a founder, consultant at E&E International Consultants in Tanzania, Pooja Mahindra. She also has vast expertise in the space of environmental conservation conversations. You know, she's a member of Mineral Law in Africa, a research chair in South Africa at the University of Cape Town. And I'm very excited to hear from her. Pooja, we welcome you. Kindly address how big this can get in addressing mining and the planet. Are there environmental conversations that we are overlooking as legal professionals? Are our laws able to, inculcate most of these things in them? And how do we as legal professionals play a key part in ensuring that this discourse just doesn't stay on the surface, but we can also think about our environment? Over to you, Pooja.
Thank you so much, Michael. I've shared my presentation. Can you view it?
Yes.
All right. Thank you. Thank you, and good afternoon, everyone. Good afternoon, the panelists. Good afternoon, the participants and peers committed to responsible mining practices. I'm going to be discussing the legal pathways to environmental accountability. The mining sector generally is very essential for any nation's economic growth, in the sense that it leads to subsequent development of other sectors. It brings in local content benefits through employment, through service sector development, and the likes. However, it is a sector which is most environmentally disruptive. In what sense? That it creates land degradation, it increases pollution, the common impacts that we all know: tailings, toxic waste, and long-term and irreversible impacts. While at the same time, the Paris Agreement, which most of the East African countries are signatories to, call upon these countries to align their policies and laws to climate-friendly goals. And yet at the same time, the Sustainable Development Goals reminds us to have an inclusive, climate resilient, and just legal systems. So I'm going to be discussing how these environmental standards can be embedded into the law by discussing three main tools. The first being the environmental impact assessment, mine closure plans, and the third being climate resilient legal frameworks. Let's first look at the actual problem on ground. Environmental impact assessment, for example, are just conducted as a formality. Surveys conducted with the environmental officers in Uganda in some study revealed that only 35 to 40% of the proposed mitigation actions are actually implemented. There are poor mine closures, and there is still severe land degradation. In Kenya, for example, at the Severite gemstone mining in Taita Taveta County. Pollution still continues, for example, in Tanzania's North Mara gold mine, where local communities reported water pollution from mine operations and is linked to multiple deaths of villagers and livestock. Geita gold mine also reports show that there are elevated levels of cobalt, copper, nickel, chromium, and zinc in sediments near Lake Victoria and Geita. All of these raising long-term ecological and human health concerns. In a similar way, Kenya, where the Kwale Titanium Project has shown incomplete EIA. All of this together shows that there is gap in our legal systems. What can therefore be done? We are therefore suggesting a mandatory and participatory environmental impact assessment into our laws. To briefly explain, an environmental impact assessment is a legal and procedural tool used to predict and evaluate potential environmental, social, and economic impact of a proposed project before any decision to proceed is made. By decision here, I mean that before granting any environmental mining permit license, it is important that EIA is a precondition which should be made or which should be done before granting such licenses and permits. The goal is to prevent or minimize environmental harm through planning, mitigation, and informed decision-making. Environmental impact assessments are very critical in mining because mining operations cause irreversible damage to ecosystems, water resources, and to the impacted and affected communities. Therefore, EIA should be mandatorily provided by the law. We will now look at the stages of an EIA process and see what the law may mandatorily provide for. First is the screening stage, which determines if a project needs a full EIA or not. It is usually provided mandatorily by the law, and public participation mostly is not required. However, best practices recommend that early notification to communities should be made and they should be involved in the screening stages. Second is the scoping stage, which identifies key environmental and social issues to be studied. It sets out the scope and the terms of reference of an EIE study. Public participation is recommended and is often mandatory to involve stakeholders and affected communities to identify their concerns so that they can be resolved at an earlier stage. The third stage are baseline studies, in which data is collected on current environmental, social, and economic conditions. It involves biodiversity, water quality, land use, and livelihoods. Public participation is recommended to gather local knowledge and validate data accuracy. The fourth stage is impact prediction and assessment. This stage predicts the positive and negative impacts of the project, and it assesses the air, water, soil, biodiversity, social, and cultural effects. Here, public participation is recommended, allowing communities to raise concerns about their underestimated risks. The fifth stage is mitigation measures. proposes ways to avoid, reduce, and compensate negative impacts. It includes pollution controls, restoration, benefit sharing. Public participation is recommended and is beneficial to ensure practical and culturally appropriate solutions. The sixth stage of an EIA process is the EIA report preparation. This compiles all the findings into a detailed environmental and social impact assessment report. It should be transparent and it should be evidence-based. At this stage, public participation is very, very important, and the report must be disclosed for public review. The seventh stage is the public consultation and review stage. This is a formal stage where the EIA report is shared with the affected and impacted communities and stakeholders. This involves mandatory public participation, includes public hearings, comment periods, and feedback mechanisms. It ensures transparency and incorporates local views in decision-making. The next stage is decision-making, where the regulatory authority approves, rejects, or revises or requires revisions to the project. Public participation is often limited, but should be informed of the decision. Some laws require publication of the decision and reasons. The last stage is monitoring, compliance, and follow-up. This ensures project follows environmental conditions during operation. It includes site inspections, audits, and impact monitoring. Public participation is recommended for community-based monitoring and reporting violation. One important thing to note here is that for adequate public participation, adequate provision of information is very, very important for the public to meaningfully participate. Most of the laws of East African countries lack this thorough process and this thorough provision of public participation in the whole EIA process. Thus, it's important for the laws of these countries to mandatorily provide for public participation in each of the relevant stages. The next legal solution that may be embedded in the laws of the East African countries is the legal provisions for robust mine closure and financial assurance. One thing that can be done is mandatory mine closure plans, which may require all mining companies to submit comprehensive closure and rehabilitation plans even before the project approval. So this again, before the mining licenses or the petroleum licenses and permits are given, what may be requested mandatorily is the comprehensive closure and rehabilitation plans. Plans must cover progressive rehabilitation during active mining and not just at the end. It should include restoration of landforms, water quality management, and ecosystem recovery. Secondly, the laws could align with international standards, an example being the USA's Surface Mining Control and Reclamation Act, which provides or which mandates detailed closure and reclamation procedures. This ensures that closure plans address soil stability, water protection, biodiversity restoration, and long-term land use. Thirdly, phased closure and progressive rehabilitation may be provided in the law, where legislation would require phased closure, rehabilitating mined areas progressively to minimize environmental footprint. This prevents large-scale abandonment by encouraging continuous restoration as mining advances. Fourth is financial assurance mechanisms. This requires mining companies to provide mandatory financial guarantees right at the beginning, such as bonds, trust funds, and insurance. Financial assurance must cover full cost closure, cost of closure, rehabilitation, monitoring, and potential contingencies. Fifth, multiple stage financial guarantees could also be legislated. This includes implementing multi-stage financial assurance, where portions of the bond are released only after completion of progressive rehabilitation milestones. This prevents premature release of funds until an independent authority certifies successful closure. Sixthly, the law could provide for independent verification, whereby an independent agency or panel to review and verify closure success before financial guarantees are released. Verification includes inspections, environmental monitoring data, and community feedback. The law could also provide for legal accountability and penalties, whereby it could make it illegal to abandon mines without approved closure and rehabilitation. The law could also impose penalties, fines, or criminal liability for non-compliance or fraudulent release of financial assurance. Moreover, public transparency and participation can be provided by the law, which could require the companies to publicly disclose closure plans and financial assurance. This includes community involvement in monitoring closure progress and post-closure land use. Further, the law could provide government access to these funds. If a mining company fails to perform closure, laws should allow the government to access financial assurance funds to carry out closure and remediation. This ensures clear procedures for government intervention to protect public and environmental interests. The third legal tool which we are suggesting is integrating climate resilience and global climate goals into the East African mining laws. So the laws could first define climate resilient mining legal frameworks. This includes mining law requiring climate resilient operations by integrating emission limits for mining equipment, transport, and processing. It includes energy efficiency standards, such as mandatory use of cleaner technologies, and it includes climate risk assessments for events such as floods, droughts, and temperature rise at project approval and review stages. Secondly, the mining law could also align with global climate goals, such as the Paris Agreement, whose global limit is well below 2 degrees Celsius, also aligning with the UN Sustainable Development Goals, such as Goal 13, which requires climate action, and Goal 12, which requires responsible consumption and production. This may also include requiring large mining firms to develop and report net zero or carbon neutrality roadmaps, and promoting mining codes that mandate disclosure of GHG emissions and climate risk audits. Thirdly, the law could leverage green finance to drive compliance. Studies from BRIC nations such as China, India, South Africa have shown a success by incorporating green finance tools such as the green bonds and the ESG investment rules. This has led to measurable carbon dioxide reductions in mining sectors. Thus, East African laws could also tie financing eligibility to sustainability performance to improve climate compliance. Other practical tools to be embedded into the law include introducing carbon budgeting clause in the mining agreements, mandating use of renewable energy in mining operations by certain deadlines, creating a climate resilience certification for compliant mines, and providing a legal recognition and protection for mines using circular economy principles. Finally, let's look at accountability and access to justice into the laws. The mining laws of the East African countries could be strengthened by strengthening the enforcement mechanisms, which include administrative fines, criminal sanctions, independent mining ombudsman, or environmental commissioner, whereby such an independent statutory body could receive complaints, could conduct investigations, could recommend penalties or mediation, and could monitor government enforcement performance. Further, the concept of environmental democracy should be leveraged into the law by providing enforceable rights to access to information, public participation, and access to justice. Further, on access to justice, companies or mining projects should generally have mandatory grievance redress mechanisms, whereby every mining project must have an accessible and independent complaints process. But this process should be time-bound and should allow for escalation to courts or to environmental tribunals. Further, mining laws should allow or should provide for public interest litigations with clearly defined legal standing for affected and interested communities, standing for CSOs, indigenous groups, and public to challenge non-compliance. This should be going hand in hand with legal aid or support for marginalized communities to file climate and environmental cases. Concluding my presentation, I would say that embedding strong environmental standards into mining regulation is no longer a choice, but it is a necessity for our ecosystems, for climate stability, and for communities whose lives are shaped by resource extraction. To move forward, East African countries must work together to harmonize these mining laws and environmental laws, whether through mandatory and participatory EIAs, robust mining closure obligations, or through climate resilient legal framework. Collaboration is the key, as impacts of this sector run across nations. Regional alignment will not only create legal certainty for investors, but also raise the floor for environmental protection across borders. Just as pollution and climate change know no boundaries, our solutions must also transcend them too. And I think this is what takes us to the next presentation. Well, I would take this back to Michael. Thank you so much, everyone, for your participation. And I look forward to any concerns or questions.
Okay, thank you so much, Pooja, for the presentation. And for me, it's a very good time for us to nuance the conversation with the role of EIS in all of this. And I think something that's also very much overlooked, which is the decommissioning plans in the mining discourse, where the interest is on get the minerals out, but what happens to the climate and environment generally after that. And for me, one of the other things that I felt the participants need to take away, especially legal practitioners, is always look at the government's commitments to these international instruments, the Paris Agreement, the UN Sustainable Development Goals, as you advise your clients to partake in these activities, to know that there are environmental considerations as well that are obligations for the state in this sector. So I want to thank you very much, and I want us now to nuance the conversation back to also the business side of things and to the governance side of things. So our next presentation is going to be from Cynthia Opakas, who will be discussing the topic of beyond the license. There are many issues that we've been talking about now, but it all gets back to the license holder. How accountable are they? How will they be, tied down by the host state and host communities to make sure each and everything that has been discussed before this moment is actualized? That's the license to partake on all these mining activities. So I want to welcome you, Cynthia. Over to you to take it away. And yes, looking forward.
Thank you, Michael. So my mandate today is mostly to speak about the legal regimes that we have in East Africa, what we can do better, and also just how to balance, beyond the license, as you say, how to balance investor expectations versus community. A lot has been said by the speakers before me. And I think we all agree that the bottom line is to use our resources to benefit our people. And it's not just, I think that is embedded in most of our constitutions. For sure, it's embedded in the Kenyan constitution, equitable resource exploitation for the benefit of the people. And we do acknowledge that, of course, in the region now, we have a lot of critical and strategic minerals that are important and also critical to the energy transition. Of course, we have, speaking of DRC, that's a big giant. We also have other mining giants in the region, Tanzania, and like for Kenya, we have rare earth, as has been said. And of course, we are moving from a fuel intensive to a mineral intensive energy system. So it's important to just have these conversations around mining and around the law governing mining. So in terms of, what our laws are kind of getting right and what is going well, I wouldn't say, speaking for Kenya, for instance, we have our Mining Act 2016, which was an update from a 1940 law. So it was a big kind of wake up moment for Kenya when it comes to mining. And of course, the past 2-3 years, there has been discussion or conversation around amending that law to include other things like mineral rights authority, and to have a dispute resolution framework just for the mining sector as we do for the energy sector. Is that a priority? That's a different conversation altogether. But in our laws, increasingly, we see now a lot of resource nationalism. We see that our governments now, and this I think is visible in all the mining laws across the region. We see, for instance, free carried interest for large-scale mining companies. That's the case for Kenya. I believe it is the case for Tanzania as well. There is a case for artisanal and small-scale mining to only be applicable to like for instance in Tanzania to Tanzanian nationals. So there is, and of course that comes with challenges, the technical capacity and whatnot. But then of course we see a lot of that resource nationalism and just the quest to have our resources benefit us, that's being embedded in our laws. We also see a lot of community protections in our legal framework. So this go into, as has been mentioned before, the royalty frameworks, the benefit sharing frameworks. We want to see beneficiation. And of course, this goes into a different discussion if you look at it. And also we need to attain or achieve a balance in terms of and looking at communities generally as partners and not as victims, right? Of course, there are instances where investors, and not just in the mining sector, but in project development generally, communities suffer because of actions of investors. But all things constant, all things right, I think communities should be viewed as partners, and our laws in the region really have kind of done a good job in having this beneficiation frameworks. And so when you speak communities, of course, there's a royalty conversation that comes in. There's land use in places where you find land is held by communities. I'll give an example of Kenya, where the land should be registered to a community where it is not. It's held in trust by the county government. And some of those protections that now we see being embedded in our laws are a good thing. Pooja just spoke to environmental protections, which also are now embedded in a lot of our laws, because by the time before you give a license, you want to see what is your environmental plan, what is the decommissioning plan. We've seen decommissioning plans can change. And it's a long period of time from project development to by the time you're doing your post mining work. We've seen Best Titanium now just exiting Kenya, and I recall the work on, say, the post mining land use started 3 years ago. So it's a long journey, especially for large scale. And Michael, as I speak, of course, part of what I say transcends between ASM small scale, and some of what I say applies to large scale players. Of course, in the region now, we are also seeing incorporation of technology into our laws and mining cadastre portals. Whether that is efficiently working as we would want it to be is also another conversation. And for instance, when you have small scale miners, expecting them to apply for licenses, there's also a bit of the technical capacity building that should go into that, because first of all, you would have to have the internet or a smartphone or which is a good thing because it just reduces the time between you and having to go to a government office somewhere and apply for a license. And also, ideally speaking, what we would want is to see this kind of mining cadastre portals enhance interagency collaborations. For instance, you'll find in most of the laws in our region, the environmental laws are found in one piece of legislation. There, for instance, then you would have to get an ESI approved. So in an ideal platform, this mining cadastre portal should be able to enhance those interagency collaborations and reduce that human element that has the net effect of increasing transparency and efficiency. I also have to just I've of course mentioned the communities, and local content, I think, is also a big part of what our sectors do well, and what is currently reflected in our laws. Of course, this is not just limited to knowledge sharing or research and development or employment. But also as a mining company, where you're getting your equipment, all that goes to local content. And it's something that I think personally should really seriously be enforced, because we don't want a situation where you have an investor who's undertaking operations in your country and literally everything is being imported from outside. Of course, giving an example of Kenya, we are now seeing like our Mining Act has local content provisions embedded in it, but we have a law that has stalled for a long time, a local content bill that has stalled since 2018. And now what we're seeing is different industries and different sectors are now looking to have their own local content regulations. We saw Kenya Petroleum just gazetting the local content regulations being gazetted for the petroleum sector in Kenya just the other day, around three weeks to a month or so ago. And of course, so what I'm essentially saying is we have a good, on average, a good framework of legal provisions and laws. Of course, there's a lot that we can do better. And there's a lot of legwork that has to go into the implementation already of what we have. Because, and what we can do better, for instance, we see like in our artisanal mining or small scale value chains, is the illegitimate trade of the resources that we have. And of course, this is with poverty being the biggest driver. Of course, you find a lot of minerals crossing the borders and for the miners, especially the small scale ones, not getting value for that. Of course, in grander schemes, this have been regulated. Like for instance, the bigger players in Diamond and whatnot in the south have the Kimberley process, where you have to have a certificate and whatnot, and just have, I think the word for it is traceability, and just have better controls. So I think those controls in terms of an ethical supply chain in our region is something to look into, and also to kind of have consumer-driven controls in terms of, as a consumer, finding out where whatever you're purchasing is coming from, the geographical path of what you're using is coming from. So, and I think a speaker before me mentioned the EITI. Kenya, for instance, you're not a member country, but such initiatives are critical to just enhancing accountability and transparency in the sector. What I think also we can do better in terms of our legal regimes is just, of course, we recognize that artisanal mining is what it is. It's very small scale. It's very using, for lack of a better word, crude methods. But what is the dignity of our miners? How crude? Can we import or include some level of technology at that level, or some level of mechanization and just for, number one, for the dignity, and to, mechanization, to basically make work easier of that on that side of things. On the largest scale side of things, of course, processing and industrialization is something else that has been a big conversation in this industry. And for instance, if you got a gemstone from Taita Taveta, and this goes to value addition, you cut it, of course, the value goes up. How, depending on how sophisticated the cut is, you polish it, that's where the real value is. So you find the miner on ground does not really get the ultimate or the optimized benefit of what they're mining. So in the long run, even for large scale mining companies especially, we need to look into, and very critically, into value addition, into processing, and at all levels, really. Because for large scale, of course, processing is, I gave the example of base titanium, where the resource is obtained here, but processing is done elsewhere, and also that's in the value chains. That increases the value. But then, of course, this is dependent on many other factors. Of course, that you would need a lot of energy for that. It also goes into the debate of reliable energy, and energy security and affordability of it. It goes to infrastructure, because if you're moving this, then of course your infrastructure has to be good. I think there is an example in Zimbabwe that has done a lithium processing plant. I think there's a Chinese-owned lithium processing plant in Zim. But it helps to have, of course, that plant in the country, the value addition done there. That means jobs. That means various other benefits to the country. Also, just speaking to how our laws also align to international frameworks. I am aware that there is a working group put together by the African Union for a mining model law that would kind of just guide us as a continent, and not just as the East Africa region, but as a continent, on our mining laws, just to avert or minimize a situation where you go to one country, the controls are so high, you go to the next one, and also just to reduce that kind of risk of political exploitation. So, of course, we have the Africa Mining Vision, which is now being implemented by the Africa Minerals Development Center. And they're doing a lot of work. And now we do have a reporting standard that has been developed by the Africa Mining Development Center. It's called the Pan-African Public Reporting Standard for Minerals and Energy Resources. We also have our resources. That body has also established a resource classification tool, which is the Africa Minerals and Energy Resources Classification and Management System. So these are tools that kind of go to giving us the best practices. I think it was somebody mentioned the OECD due diligence guidelines for responsible business conduct, because what we are looking for is not just to mine and to get the benefit, but it is responsible sourcing and responsible mining for sustainability and for the benefit of the current and future generations. Finally, Michael, to go into the balancing of the investor confidence and community expectations, which is always the elephant in the room. And at this point, then we have to look at put yourself as an investor and as a member of the community. And what are you looking for? So of course, as an investor, you're trying to get value you're trying to be profitable. You're trying to obtain value for your shareholders. You're trying to obtain the social license to operate. So you want once this project, and these are long-term projects, you're going to be here for over 10, 15 years. You want to make sure that your safety and security is guaranteed. So of course, some of the protections of as an investor and at the point you're doing your project development stage, you're looking at things like do we, for instance, have a bilateral investment treaty with this country? And if we do, then if that goes into then answer the next question, if there's a risk of expropriation, and then you're able to get compensation, thinking of backwards in terms of what could go wrong, and if that thing that went wrong happened, then how do you what is the recourse that you have? Of course, is it an ICSID member country and some of those things, just in addition to this is where we've done exploration and this is the country that where we are looking to for investment. So that also needs a lot of collaboration with government and a lot of collaboration with local communities. If you are the local community, you're looking at there's an investor, they're getting resources from our land or from our country, and of course you want to get beneficiation or a benefit to reap a benefit from that. And then there's the government that's kind of in between. So, and we always say, of course, if it's building schools or access to energy or access to education, that's the role of your government, really. That's the job of the government to do that. But then, of course, and historically, we've seen a lot of CSR initiatives, and we still continue to see CSR initiatives, which are voluntary. But now we have these royalty frameworks that are now incorporated or embedded in law. And as has been alluded to earlier, you mostly have a percentage going to the local community, a percentage going to, say, if you have, like, for Kenya, we have county government, a percentage going to the county government, and a percentage going to the national government, the larger percentage going to the national government. So then you will find that the mining company will pay, in this case, a large-scale mining company will pay the royalty to the national government. That money goes into treasury. How that comes back then to the community, another conversation for another day. We have seen developments, like, for instance, now Kenya has a bill that has been stuck somewhere. It's called the Natural Resources Benefit Sharing Bill. And the biggest challenge with that piece of legislation is it bundles together everything. It bundles together minerals, petroleum, and natural resources and renewable sources of energy, solar, wind, and the like. So the practicality of that again is difficult. But then you realize when the mining company, say, has paid the royalty, there is still legally, there will still be, practically speaking, actually, there will still be an expectation, because they live and they coexist with the communities. You still have to do something because you have paid the royalty. How is that really coming back to benefit the community in terms of projects and whatnot? That's out of your hands. But you still have to protect your investment and to protect your assets. So there has to be a lot of collaboration in terms of what happens there, and mining companies just really taking like from profits to pay royalties as enshrined in law, and also just to manage the communities, because you have to get that social license and for the safety and security of investment. And then also there's just also the ESG aspect, which I will tie to my final point. Because for mining companies, and really right now, because the money is the biggest, financing even for these large-scale mining companies is a big thing. And that's what is going to drive your operations, whether you're going to finance through debt or equity or whatever. But what your financiers want to see is your ESG compliance. And you'll see in your facility agreements, more likely than not now, you're going to have ESG reporting frameworks and reporting requirements. And we're seeing this even for not just in private debt, but also in terms of even banks now, climate-related disclosures and ESG requirements for borrowers. So, for instance, in facility agreements, we are now beginning to see things like you need to have an ESMS, that's an environmental and social management plan. And you need to have that in place, and annual reporting frameworks of how many women are in your boards, and how many young people are in your boards. Have you had any community incidents? Of course, you'd classify that into what is an incident, what's a serious incident, and reporting framework. So that existence of ESG within the reporting framework could very easily, as an investor, stand between you and your financier. So those are critical considerations. And also just as a takeaway and as I finalize, of course, global ethics are changing, and you will find some of these things, there's no standard, they're not in a standard way kind of coded in law, but then we're seeing a lot of industry practice among financiers and amongst lenders, just to see, that integrity, that's ethics, looking at the ethical sourcing, looking at the coexistence and environmental management plans showing up in the lending offers, in the lending agreements. I think that is it for me. Just to also, as I finalize, of course, there's a lot of good things that are working for us in our laws, and I think there's a lot of more legwork that there is to do in taking off, because we are still having conversations of that, how do we deal with communities? How do we make sure we capacitate our people, land issues? And the law, as we have seen many times, is always playing catch up. Now things have moved to, the impact of, geopolitics in the mineral sector. The other day we saw the US brokered a deal between DRC and Rwanda, and what is in the public domain, as reported, is that minerals are at the center of that deal. We've seen AI now being used for exploration. I think there's a cobalt mine in Zambia that is using AI for exploration. So the target is constantly moving and changing. So I think the priority for us as a region, it's also just to also do our best, and there's a lot of legwork to go into implementation of the current legal frameworks that we have. Thanks, Michael. I think I'll stop it at that.
All right. Thank you very much, Cynthia. And I think for me, you've gone deep into it and done justice to really examine all these intricacies relating to issues that investors deal with and what states have to do, but also most importantly, what us as legal professionals have to be thinking about. But the lingering question, and for me, that's what the last speaker will be coming in to discuss. Cynthia paints a clear picture that shows that we're playing catching up. So for me, the question is, are we ready for the demand for these mineral resources, or are we even catching up fast enough? Because from Cynthia's presentation, it's rather very clear. The demand for beneficiation is there. The demand for the resources in the way they are is there, but are we catching up enough to make sure that our communities can be an integral part of this, wealth, benefiting from all aspects of how they're compensated from their land and how they get knowledge in terms of value addition and contributing more responsibly to this entire sector. So with this, I want to invite you right away, Daudi. I want to invite you to particularly get together every piece, because your topic is there are fragmentations, but I want us to see how unity can be seen in conversations around mining governance across our countries. You could start with East Africa, but you can take it away as wide as you want to see how best we can harmonize mining governance in our region. Over to you, Daudi.
Thank you very much, Michael. Are you able to see my screen?
Yes, I am.
Fantastic. Thank you very much. I would also like to thank my my fellow speakers who have done really good justice in terms of their topics. So just to give a bit of introduction, my name is Daudi Ramadhani. I am a partner at Rex Advocates in Tanzania. I've been with the firm for the good 15 years, and I'm an advocate of the High Court of Tanzania. Currently, I serve as the chair of the Mining Law Committee of the East Africa Law Society, and my work spans a broad spectrum of corporate and commercial law. And over the years, I've advised major project mining projects in mining and energy space, which, based on this background, I speak to you today to share my experience about the need to harmonize the mining governance in East Africa. So just to start, we all know that mining sector is the cornerstone of our development, and it contributes quite significantly to most of our economies. But despite the mineral wealth that the East African and the region as a whole is blessed with, we are still not unlocking its full potential. Why is this? Because in my view, I think legal and regulatory frameworks play a major role in terms of streamlining and making sure that every country is able to benefit from its natural resources. But unfortunately, the reality in the region is not as such. Every country has its own mining laws. Look at the royalty rates that are being charged in different countries. They are all different. Environmental obligations are different, and so on and so forth. So it's like, we're playing the same sport, team sport, but everyone is following different rules, which, to be quite frank, it's somehow very counterproductive in terms of making sure that we are all moving together towards the right direction. So in terms of why, answering the question, why do we need harmonization of our legal and regulatory frameworks in the region? We all know that unity is something which really gives us a very strong bargaining chip. So it is very important to address everything as a region in terms of creating the predictability for investors, because if an investor, for instance, comes from abroad and goes to wants to invest across Tanzania or Uganda, but somehow is being surprised by completely different sets of rules and regulation, sometimes it becomes a bit frustrating, and sometimes it's can be very counterproductive to us, because they might try to getting advantage from the less stricter jurisdiction over the ones which are quite strict. Secondly, in my view, harmonization really strengthens our collective governance. We can be able to fight things like corruption. We can avoid duplication of a lot of processes, and even the oversight authorities. We can be able to build a shared enforcement tool that can work for all of us and share different experiences, good and bad, to see how best we can be able to improve our mining sector as a whole. Harmonization also encourages the responsible mining. If we want to build a sustainable mining sector, it's very important that we are able to bring together all our ESG standards, environmental, social governance principles, where we work together to raise the bar and making sure that health and safety regulations are being observed. The sustainability issues are also being looked at in order to ensure that not just this generation, but also the future generation benefits from the vast mineral deposits that the region has been blessed with. Importantly, harmonization also helps to stop the race to the bottom, whereby some countries can lower their standards just to compete for the limited investment resources that we're all competing against. So instead, we should make sure that we harmonize and ensure that all the safety sustainability standards are being adhered to in order to gain the value. So let's look at the current landscape of the mining governance in Africa. So it is very interesting. In Tanzania, fortunately, I see that we have seen quite a strong improvement in terms of our laws. There has been strong local content laws and increased state participation, which really helps to promote the resource nationalization, which promotes the benefits of the local community, but also the country as a whole. We have seen that there has been a great shift, as what Cynthia has mentioned, in Kenya. There's the promising reforms which came with the 2016 Mining Act, which was repealed the Mining Act of I can't remember 19 something, which was quite some time back. And this has really improved the situation in Kenya. But of course, they're still facing a couple of challenges. In Uganda, the new law in 2022 that promotes transparency and brings artisanal mining into the formal economy, which is a very welcome change. And Rwanda and Burundi, you can see that the licensing systems have been trying to be digitalized through institutional capacity, although the institutional capacity still remains a challenge. South Sudan, DRC, they also have immense potential, but still face some chronic governance issues, which is something that I believe they can be able to learn a lot from other jurisdictions like Kenya, Uganda, and Tanzania. So with these different challenges, I believe that, for those jurisdictions which are still in the early stages of the mining sector, they have a lot to learn from other countries which have been advanced, like Tanzania, in certain aspects. They do not really need to go through the learning curve which we have gone through. So it's a mixed bag if you look at the legal and regulatory framework for these jurisdictions. And it is very important for us to be able to come together, share the challenges, and see how best we can be able to promote the sector going forward. So other challenges which we can still be able to see now is that there's a lot of issues of, as I've spoken, the legal and regulatory asymmetries. The same activity might be regulated differently in different countries across the neighboring countries. We also face trouble when dealing with issues of transboundary mineral deposits. If one country is stricter than the other, investors will likely take an easier route, undermining the stricter country. And of course, we also see countries competing for investment by cutting things like taxes, relaxing some oversights, which are quite crucial. Of course, it's a short-term gain, but we do suffer at the end of the day as a region as a whole. Investors also face uncertainty when it comes to issues of taxation. There are real concerns about expropriation in some of the areas. In this climate, even well-intentioned companies sometimes can also, hesitate to make their meaningful investments in such a scenario. So, as a region, we have tried to come up with, we've made some efforts to see how best we can harmonize and streamline our legal and regulatory framework. From the East African Community front, the EAC Mining Bill 2017, which is like a model law intended to align the fiscal, legal, and environmental standards for the sector, and countries have already started seeing how best they could adopt some of these standards, and it's quite encouraging to see quite an uptick from the region. Also, we have seen that there's been an establishment of the regional mineral value addition policy framework to support the joint beneficiation initiatives. This is something which can really benefit the region as a whole, because
Daudi, it seems we've lost you. Wondering if you can hear us. Daudi? Okay, it seems we've lost Daudi, who will be rejoining soon. But as we prepare to get Daudi back on board, there is a question in the chat, which I'm hoping, Cynthia, you can help us, take a shot at. Bivli is asking, how do we ensure companies adhere to responsible business and human rights practices at the point of in-country establishment, and that is at the point of registration or at the point of obtaining licenses? What safeguards can be put in place? I'm wondering if you want to give this a shot, maybe from a perspective of Kenya, what Kenya is doing at the point of registration of its companies or at the point of licensing.
Hello.
Okay, Daud is back, so we can hold that question for a second for you, Cynthia. Daudi, can you hear us?
Yes, I can hear you.
Okay, we lost you for a second there, but glad to have you back. Wondering if you could put your slides back up.
Okay, I don't know at which point did you lose me?
On slide 6.
Slide 6. Yeah, so I was talking about the some of the regional efforts that has been being done in order to see how best we could harmonize the legal and regulatory framework. And I said that at least from the East African community front, there has been some, level of harmonization happening. The EAC Mining Bill 2017 has been, is in place, and this is like a model law which is intended to align the legal, fiscal, and the environmental standards which countries are, are required to adopt. And there has been quite a good uptick from these countries in the region, which is a very good initiative. But also there has been an establishment of the regional mineral value addition policy framework to support the joint beneficiation initiatives. As I said, we all know how capital intensive the mining business is. So when we have some of these efforts being conducted jointly, I think it will save us a lot of time, resources, and efforts in terms of seeing how best we can leverage on every country's strength. Also, the East African community has called for shared data systems and the regional geological survey to aid harmonization. This is something which is very important because each country can be able to, share what sort of deposits, what sort of geological data the country has in order for the, for the region to be able to access and see how best we can be able to capitalize on it. From the Africa Union front, we have also seen the Africa Mining Vision 2009, which is a Pan-African policy framework promoting equitable, transparent, and sustainable mining. Like the East Africa community, the Africa Union has also been promoting for member states to be able to adopting some of these policies in order to ensure sustainability of the sector. But also the AU has been focused on resource-based industrialization, issues of value addition, and integrating mining into the broader development. We all know now issues of rare earth mineral is such a hot topic, and the Africa Union has been trying to see how best we can be able to establish some industries so that we could promote beneficiation, but also do significant value addition in order to benefit the region from selling finished products rather than continue with promoting the sale of raw materials. But also the AU has been pushing for collaboration with the Africa Mineral Development Center to promote technical assistance for legal reforms. This is something which is very important because we have a lot of skill gap in terms of having technical skills of this sector. So through our joint efforts, we can always be able to capitalize on the limited skills that we have in the region in order to take the industry going forward. Other initiatives which have been done by the region is to promote issues like the intergovernmental frameworks in terms of the mining policy frameworks, but also promoting transparency in the extractive industries. As we all know that this is a very important sector and contributes significantly to the economies. So transparency has been something which is very key for most of the countries. And these, both the AU and the East African community has also been promoting for this in order to make sure that the resources, they do benefit the people of these countries in order to promote economic development. So looking ahead, in terms of, where are we going? The way I see it is that we're going to have a harmonized East African Mining Code or protocol, which is aligned with both the East Africa and the AU standards. As I've said, we have already started making some efforts. Strides have been made, but of course, there's a lot of work which needs to be done. But also, other speakers have spoken about harmonizing the, dispute resolution mechanisms to see how best we can learn from different experiences from different countries and having our own unique way of resolving these disputes. I think it can be very, very helpful. As I said, it's a capital-intensive sector, so investors will definitely want to have dispute resolution mechanism that is time conscious to ensure that the investment cannot be devalued in anyhow. But also, we see that there's a strong move towards having a cross-border infrastructure for mineral processing and transportation, which is going to be a very good thing to have, because having a cross-border infrastructure, it will help minimizing the wastage of resources by different members, and instead we can use our joint efforts to develop few reliable and infrastructures which are in a very good standard, which are going to help our mining sector. We also see that most of these initiatives by the regional bodies will eventually promote collaborative licensing of shared mineral belts and harmonized environmental standards. As we know, these environmental issues have no borders, so having a harmonized system will definitely help to promote the sector. So in terms of what we can do as lawyers, I think our role is quite critical, because we understand that the legal and regulatory framework is at the center stage of making or breaking the sector. So we can advocate for harmonized policies and legislations through our association. So situations and sessions like these that the East African Law Society is organizing, they're quite instrumental in terms of planting that seed for a harmonized legal and regulatory framework throughout the region. We can also support our respective governments in reviewing and aligning national laws with regional frameworks. We have crucial role of advising our governments in terms of which are the better ways to frame our documents, which are the better ways of structuring those contracts. So we can use that role and make sure that we are able to unify our practices, but also building legal capacity in negotiations of mining contracts and international arbitration. As I've previously indicated, that this is something which requires very strong skills in terms of analyzing and understanding the issues which are pertinent in these mining contracts and international arbitration. So building capacity on this area, it is quite needed in order for us to be able to address the challenges that come with the sector. Also, it is quite important to make sure that we facilitate cross-border investment through advisory on regulatory convergence. So just to wrap up, it is important to start imagining a situation whereby the East Africa region has one mining code. Of course, I do understand that we are all at different stages of sector development, but at least having one mining code would make sure that we have less confusions and more collaboration, shared mineral data and licensing. Dispute will be resolved very timely, but most important, we can be moving as a whole, as opposed to leaving anyone behind. So as legal minds, we have a role to play. Let's make sure that we are taking advantage of our positions to see how best we can champion the harmonized laws, advise the government, we sharpen our skills, help investors to navigate these multi-country compliances and complicated scenarios in order to make sure that we are able to move together. So that brings me to the end of my presentation. But I would urge each one of you to start thinking about this harmonization issue very seriously to see how best we can benefit together. Thank you very much. Now maybe we can get some questions or comments. Thank you very much, Michael.
Yeah, thank you so much, Daudi, and most importantly for tying everything up in the spirit of unity, and also appreciating that whereas we aspire for unity, we have different stages of growth, and we need to be cognizant of all those needs as we tie everything together. But thank you so much, and many thanks to all the panelists. I know we have about 6 minutes on the clock left for all of us in this discussion, but I'm going to ask that the remaining panelists can bear with me to address the questions that are in the chat in the remaining 5 minutes. So I'll go back to you, Cynthia. We had a question, the first question in the chat was on how we can ensure that companies adhere to responsible business and human rights practices at the point of registration of these companies or licensing of these companies. I don't know if you want to take this from a perspective of Kenya or, shared experiences, and this can also be borrowed by other countries. Over to you.
Thanks, Michael. I can think of it from the perspective of, because by the time you're registering, a subsidiary or whatever, there's very little, and large mining companies all over the world, of course, they've had some of these contentious allegations against them. So at the point of registering a subsidiary or a branch of, say, a mining company, at that point, you're just registering a business. But then at the point of licensing or permitting, of course, there are these plans and conditions that are given to your license. So of course, the moment you breach that license, then of course there's the risk of revocation or suspension of your license.
But thank you so much, Cynthia. I have another question from Imam. For acknowledgement's sake, the first question was from Bivli, and I hope it's been well addressed. I have a question from Imam Mugisha. He says, good work, team. My question is, how important are the new initiatives like the EU Critical Minerals Act that clearly highlights accepting minerals only from a conflict-free zone? The Africa Green Mineral Strategy is also another initiative, but resource-backed conflicts continue to happen in DRC. Now, the UN is suggesting a panel of advisors on critical minerals, and these initiatives aren't delivering on their purpose. Not sure if this is a question. Okay, so the question is, how important are the new initiatives? I don't know if that's the spirit in which the person asking wants it to be answered, or from us from an angle of how do we make sure we align the global discourse to our realities in Africa, in the sense of some of our minerals coming from conflict areas, and our aspiration to all be able to trade equitably across the globe.
Yeah, so I could start and speak to that. Of course, all these initiatives and of course the transparency initiatives that we have seen are deterrent factors. And like we had previously discussed, the general global ethics is changing. So you will see if you're dealing, for instance, in blood diamonds or conflicts, some conflict minerals, and most people will not want to touch you with a 10-foot pole. People will not want to. So it's not foolproof, but it has acted, of course, in many places. And of course, even when you're traveling, you'll see at the airport and somebody will say, okay, where's the certificate for this mineral and things like that. So little initiatives like that, I think, go a long way into deterring, the movement or propagating of conflict minerals. And of course, I say that fully recognizing that it's not a foolproof system. There's still there's still porous items or structures within that, such that these resources are still moving and they have not been ethically sourced. But I think these initiatives go a long way in terms of deterring, and also anybody who works in the industry would want to make sure these controls are maintained.
Okay, thank you so much, Cynthia, for that response. Daudi, do you want to add your voice to that, especially from a perspective of Rex Advocates, and how you are, supporting many of your clients to see that um, they trade responsibly, and they can also support their communities to be part of this global wave to, trade with the EU, to trade with the United States, because I've also seen a comment related to that. Are there things that we can do as lawyers to see that our clients can perhaps be ready to trade? And by clients, I'm speaking about some of the small scale players that we have, indigenous small scale players that we have in our member states.
Yeah. Thank you very much, Michael. I think just to add to what Cynthia has said, I also do acknowledge that it's not a foolproof system, but at least it's a step towards the right direction. Because nowadays we see there's a lot of interrelation between business issues of human rights, business issues of whatever surrounds the business. So it is quite essential that businesses do stick to ethical procedures, not just to use whatever investments they have done towards instigating some conflicts or plundering. There has to be some order to the game. And I think as lawyers we do hold a special place in terms of assisting our clients to advise them that these two things go hand in hand, and also adherence to these international frameworks and standards is actually very, very critical. Thank you.
All right, and maybe you could also comment on Esther's question. She says that considering the diversity in our mining laws, and something that you ably presented about, mining activities across the region are equally diverse, and we as lawyers need to communicate. So her question is, how can we communicate and network as mining lawyers? I think this is really a small space of lawyers that have cut out a niche in this. I'm wondering whether you could speak about this from the perspective of the cluster chair and how we can use the platform. Yes.
Yeah. Yeah, thank you. I think there's a lot of room for us to collaborate. There's a lot of room for us to network and to share experiences through platforms like these. But also, we do have quite an open communication throughout the region by getting in touch to any of the lawyers who are doing mining to understand, what are the current trends, what are the issues that we are seeing in the pipeline, see how best to, tackle them. But most important is through, networking and, sharing experiences through platforms like these, but also, networking during, various meetings that the East African Law Societies is organizing throughout the region.
All right. Thank you very much for that. There's also a question from Alex. Before I get to Loyola's question, which I hope will be the last one that we shall be responding to, Alex is asking a very fundamental question: what specific legal and institutional safeguards should East African countries prioritize to ensure such deals translate into sustainable development and equitable resource governance? In your presentation, Daudi, and I hope you could take a shot at this and Cynthia could add her voice to it. You presented ably on what's happening to unify us as member states. I'm wondering whether there is a thing such as legal and institutional priorities in terms of safeguards.
There has been some efforts done towards, making sure that our institutional capacity is built in terms of not only to having good laws, but also having the oversight agencies which are quite robust and able to, keep up with the modern investment world. And I can see this happening in Tanzania. We have a very able mining commission, which is doing a great job in terms of doing the oversight, the ministry from the policy level. So all these institutions are being, revamped every now and then, just to make sure that we have a better institutional oversight. I believe the same is happening in Kenya through the, their mining commission, which is, overseeing the mineral sector. So there has been a lot of efforts, and you cannot really pinpoint on one exact institutional capacity that needs to be built, but across the sector, there has been a lot of efforts done, and things are happening.
All right, thank you. And as I invite Cynthia to also add her voice to that, I would, because Loyola's question is closely linked, we have some statutes that have not yet been ratified, like the MDC statute. I'm wondering if we have proposals as panelists to expedite these, ratifications or these instruments. Cynthia, do you have any tips to government?
Yeah, of course. A lot of this is also hinged on government priority areas. And also once some governments realize that mining, of course, offers a big contribution to their GDP, then seeing that economic benefit, access to jobs and whatnot, gives it a priority, makes it a priority area. So then initiatives will be pushed for those government and those particular countries to ratify the AMDC statute. Like I said, it's number one, government priorities, and number two, it could be and there's an element of politics that goes into this, right? You'll find there's a cabinet secretary who comes in, and there's no structure. There's no structure in terms of how countries have structured their state departments for mining. You'll find, and in one country in the region, it's bundled together with water and energy. So a little bit of those nuances come in, but I think collectively just increasing our voice and our participation in forums such as the Indaba, and just keeping ourselves and making sure government has the right advisors, and so we can just realize the full potential of this sector will be key. Thanks, Michael.
All right, and thank you so much. Colleagues, in the interest of time, those are the questions we shall be taking. And of course, I acknowledged there is the good comments that were coming in from Diana, especially on Pooja's presentation on ESG and our compliance to aspects of the Paris Agreement and related instruments. I want to appreciate everybody who is sharing comments. The chat is still very busy, and I think there's too much knowledge being shared there. So the call to action to the ELS is really to appreciate that we can exhaust everything we wanted to discuss in just this webinar. But I'm really hopeful under your leadership, Daudi, that the ELS will take this a notch higher and organize further conversations to unpack even deeper questions on ASAIMs, on even ESG, if you were just scratched on the top of it. There are a lot of conversations. Loyola brought in the question on what we need to do as from an AU level, and making sure we fast track all these discussions. But there's also a fiscal regime question, which I feel is a discussion in and of its own that we need to unpack. So the sector is growing steadfastly, and I want to appreciate our panelists for volunteering their time to unpack some of our key questions that were posed to them and to guide this discussion through their brilliant presentations. Ladies and gentlemen, I want to thank you all for being with us from the beginning till now. This webinar was organized by the East African Law Society, particularly the mining sector, the mining cluster. And I invite you all to attend or to look out for all other webinars organized by the ELS. I want to end there and wish you all a very fruitful weekend and afternoon for now. Thank you very much. The webinar ends now.
Thank you very much,
Blair, and our esteemed panelists. Thank you so much for putting off time to do your research, but also participate in this very wonderful webinar session. It's been thought-provoking, and like the sentiment is across the table, we need to have more of this. So we'll be planning another webinar session, ostensibly in the month of September, and we'll have more of these discussions. But we also hope to have such a discussion at our annual law conference happening in November 2025 in the beautiful city of Addis Ababa, Ethiopia. We hope to see you all there. And we also have an in-house council convention happening 28th and 29th of August 2025 in the beautiful city of Kigali, Rwanda. If you have not yet registered for this wonderful convention that brings together over 300 in-house counsel from across the region and beyond, please visit us at elosociety.org or reach out to us at info@elosociety.org. We'll be right here to answer all your queries. We hope to see you again next week. We'll be having another wonderful series of webinar sessions, so you want to look out for that. For now, we want to thank our panelists and you, our esteemed participants, for being part of this exceptional session. Thank you for keeping your high numbers. Until we meet again next week, we wish you a very blessed weekend. Stay safe, and we hope to see you again. Goodbye.
Bye. Goodbye, Gabriel.
Thanks, bye.
Goodbye. Thank